The following news flash is brought to you by the Lone Star Lowdown. Markets for Friday, the 17th of June, 2016, are currently trading with gold at $1,290.58 an ounce, silver $17.39 an ounce, Texas crude $46.21 a barrel, and Bitcoin is still on the rise at 751 U.S. currency. Today in history, the year 1885, the Statue of Liberty arrives in New York City aboard the French ship Laser. It was designed by a French Freemason sculptor, Frederic Auguste Bartholdi, and built by another French Freemason, Gustave Eiffel, famous for building the Eiffel Tower. Though the Statue of Liberty wasn't completed and dedicated until October 28, 1886, it first arrived to America from France. Today in history. In recent news, the United States is set to keep their destroyer, the USS Porter, in the Black Sea in spite of Russia warning that the U.S. patrolling there undermines their regional security. Establishing its presence for over a month now, this initiative from the U.S. falls within a greater push for NATO to have a presence in the Black Sea in expectation of the NATO summit in Warsaw next month. If you recall, the presence of U.S. warships in the Baltic Sea caused a near flyby by Russian fighter jets, in which Secretary of State John Kerry said that the U.S. would have been within its rules of engagement in shooting them down. Navy Secretary Ray Mabus aboard the USS Mason, another U.S. destroyer in the Mediterranean, told Reuters on Thursday that, quote, "We're going to be there. Speaking of the Black Sea, we're going to deter. That's the main reason we're there, to deter potential aggression." However, he did admit that, quote, "If a decision is made to create a permanent force, of course, it would destabilize because that is not a native sea." Increasing tension between the two superpowers, the U.S. Navy deployed 2 aircraft carriers in the Mediterranean ahead of the NATO summit as Washington seeks to balance an increase in Russian military activities, also in the Mediterranean. A Texas state lawsuit accusing the State Department and other federal agencies of violating the Refugee Act of 1980 for failing to consult with state officials before resettling Syrian refugees within the state has been dismissed by a judge in Dallas. The lawsuit also charged that the nonprofit relief group, the International Rescue Committee, had breached its contract with the state of Texas. In his opinion released yesterday, Judge David Goodbay of a federal district court ruled that Texas's accusations had no legal merit. However, he didn't rule on whether the federal officials had violated the Refugee Act. Texas Attorney General Ken Paxton stated in response that, quote, "I am disappointed with the court's determination that Texas cannot hold the federal government accountable to consult with us before resettling refugees here. We are considering our options moving forward to guarantee the safety of Texans from domestic and foreign threats." Lieutenant Governor Dan Patrick said in a statement that Texas has the right to know who the federal government is bringing to Texas, where they are being placed, and what they are doing to guarantee the safety of all Texans. This is Rick Rohde with the Lowdown for June 17th, 2016.
Received my remedy today. Came in a box, just like they say. I accepted it for value right away, if not sooner.
We are back with Rule of Law Radio, Randy Kelton, Vet Tack. Mark, was there anything else that you wanted to add? We've got a few callers. I wanted to go ahead and bring on someone else. Randy, did you unmute him?
Yeah, I did now.
Okay, Mark, go ahead. Was there something else that you wanted to ask or add?
No, I think I've done my damage for the evening. Randy scratch his head a little.
Yeah, everyone out there is doing a great job, and it sounds like you're really tackling it.
Yeah, I don't know if it's a great job, but I'm certainly causing trouble.
That's good.
He's having way too much fun.
Sounds like it.
All
right.
Well, let you move on to other callers. Thank you much for your time this evening, Mr. Kelton. Bye-bye.
Thank you,
Bye,
Mark.
thank you. All right, Randy, go ahead and bring on James. James out of Texas.
Hello, James.
How's Randy doing tonight? How many bananas does McBride have in his banana tree?
Well, this is just kind of to test the system out. I really don't care about McBride. He's not going to be around long. He's getting ready to retire anyway. But this is all to see how the feds handle us going after them using their own laws and rules.
Okay.
So this is going to be fun. I'm just going to work the routine on them.
Okay.
And then when I get through working the routine through the federal side, then when they blow off everything, then I'll come back and go after them from the state side. We'll see what they think when I start filing against them with the state grand jury.
Okay, now I've got to ask a question. A judge is a judge, right? And the judge sits in the chair of the court, and the court is the court. Is the judge, when he sits in the chair, an officer of the court? And did he?
Wait, hold on, James. Can you move the mic down by your chin? You're getting some distortion.
Well, I've been hanging on since 8 o'clock, so my phone may be a little bit damp from sweating.
Okay, go ahead. That didn't help, so it must just be something in the connection. Oh, go ahead.
Do you want me to try to call you on another phone?
Yes. Yeah, try calling right back. We'll bring you back in.
Okay, let me call on the house phone.
Okay, and we've taken a little extra time. We lost the first segment today because we had some technical difficulties, and I apologize for that. But it happens sometimes, and we kind of struggle to keep this show going. And a lot of times we have to dig in our own pockets to keep it up. We had an archive last night because Deborah had a gig. She's a musician, and she had a gig. So when we have to make money, we have to make money, and sometimes we just have to put this off. So if you appreciate the show, if you like what we're doing, go to Logos Radio Network and check out our sponsors. And if a sponsor has something you can use our sponsors and help us support this show. And make sure you look for Randy's Beer Fund. Okay. Actually, there's no link for Randy's Beer Fund. That's kind of a running joke. Okay, James is back. Go ahead, James.
I'm back.
Oh, muy better. This one's not all sweaty.
Now, my question is, the judge is a judge, and he took an oath to uphold the Constitution. Did he take an oath to uphold the equitable common laws of the land and the statutory laws? And since he has taken an oath as an officer of the court, when he sits in the chair, he's an officer of the court. So when the judge opines, does he opine according to the Constitution? Which, if you look at the Court of Appeals or the appellate courts, a lot of times that they will come back with the initials NRE, non-reversible error. So the judge can make a wrong decision on equitable or common law and statutory law, but he can't make an error when it comes to the Constitution. Would you not agree with that?
Well, the Constitution. This sounds like the only time a judge can make a reversible error is when it goes to Constitution. But Constitution only goes to public officials.
He is a public official.
Yes, but
he's also a judiciary official. He's a public official in his personal capacity as he sits in the chair. The chair is the court, and the chair can't speak, and the chair will not make a mistake. And the court is the chair, and the court will not let a judge make a mistake if it violates the Constitution. That would be your reversible error, is if the judge violated his constitutional oath, just like every police officer, every military official took an oath to uphold the Constitution. They don't take an oath to uphold equitable or statutory laws. They take an oath to uphold the Constitution.
But it is the articulated duty of the court to determine the facts in accordance with the rules of evidence and apply the law as it comes to him to the facts in the case.
That's the judge to do that, and he has to do that according to his oath to the Constitution.
Yes, but the way you stated that, it sounds as though in order to claim an error, I would have to be able to claim a constitutional error.
That gives the power to the court for the court to correct a court's error. It won't correct a judge's error, even if the judge rules incorrectly to equity and to statutory law. If the judge makes an error on that, it's not a reversible error because it's not a constitutional error. Now, if in doing that did not go to the merits of the case to determine if he had jurisdiction or such, then he's committed a reversible error in the Constitution.
Okay, then I would have to be able to say that the judge's ruling denied me in either a procedural or substantive due process. That would go to Constitution.
Correct. That would be correct.
So any error in the application of law where the judge fails to apply the law as the legislature intended would deny me in substantive due process.
Correct.
So if he failed to follow a procedure or failed to afford me a constitutional right, that would be procedural. So what you're saying is where we have the higher courts have authority to reverse a judge's ruling is if it denies, for the most part, substantive due process.
If the court does not follow a higher court's procedures, then we get into stare decisis.
And that's where we go to substantive due process. I have a right to the just application of the law, and stare decisis defines what is the just application of law.
That would be correct. Now, the other thing that I have a problem with is we go back and look at what they're doing to the people. You can go back to the 5th century BC in the Art of War of Sun Tzu. Most people don't understand they're being indoctrinated into all of this. And you can go back to the Banker's Manifesto that Charles Lindbergh released to Congress back around the 1900s, somewhere right after 1900. And they're doing exactly what they're saying they're going to do. They're going to con people, and they're going to hold them into involuntary servitude, and they're going to make our children's great-grandchildren's pay for our failure.
Okay, I agree with that. That's the way it's always been.
Yeah, now the other thing is, if we bring a little bit of the scripture into it, you can go down to the Texas Capitol and look on the grounds. The 6th commandment, thou shalt not kill. But go back to the original scriptures. It's thou shalt not murder. They're playing word games with us. And attorneys are the most skilled word crafters there are around.
Yes, and this is one of the things we talk about a lot, that when you go to court, they do not speak English in court. They speak an English dialect. It's called legalese.
Then we deal with collateral estoppel. If the statutes sit there and say you've got a duty to do this and you've got an obligation to respond in timely, now we're looking at the 1635 rescission as collateral estoppel. They had a duty and an obligation to respond in 20 days, and they didn't do it, so they're collaterally estoppled from raising an argument later on. It's the same way as if you don't raise it, you lose it.
Exactly. And this we've been using against them, because the banks, they somehow they didn't seem to take rescission seriously. And anytime I file a notice of rescission, they treat it like a qualified written request. Yeah. And they file the same trash answer. Well, okay, there's a little more to it than that.
Statute of repose.
Well, mine actually looks like a qualified written request.
They are different.
The rescission is a little paragraph right at the bottom after 20 pages of trash discovery that they don't have to pay any attention to. The last paragraph says if you fail to properly validate this debt within the statutory time limit, consider this as a notice of rescission. I don't think they ever read it. Oh, well, life is tough. This judge I just filed criminal charges against, in his ruling, he said that the right to rescind does not last forever. Wrong. Yes, it does. Once there has been a notice of acceleration.
Consummated, then they got 3 years from the time it's consummated. But if they admit it's been consummated, then they've got to look at a breach of contract because they...
So that's different than rescission. We can do a breach of contract. But once there is a notice of acceleration, the right to rescind is reinvigorated. And that second right to rescind lasts forever. There's no time limit on that one. So the judge was totally incorrect. He read the part he wanted to and ignored the rest.
Randy, I believe we're going to have to take a break. Now be quiet. This is Rule of Law Radio. You're listening to Randy Kelton, Vet Pack. Call us at 512-646-19.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Well, don't let nothing get to you. Only the Father can deliver you. So don't let bad mind people hurt you until Satan get behind you. Know what I mean? My friend, and all of your children, come. Those things that hurt me free. Tell him your problem, babe. Call on his name once again. Miracle, you know he worth the aim. Those things that hurt me free. Tell him your problem, babe. Call on his name once again. Miracle, you know he worth the aim.
We are back. You're listening to Rule of Law Radio with Randy Kelton, Vet Pack. We were speaking with James. Randy, where did we leave off?
Okay, we were talking about the judge's duty to apply the law to the facts. And, what was it, James? Collateral estoppel. Collateral estoppel and laches. Laches go along with collateral estoppel in this regard. Laches is very specific in that where you have a right and you fail to exercise that right. But laches only applies if you had a right, failed to exercise the right, and the complainant's circumstances changed subsequently to your failing to exercise the right. And then it goes to laches. Otherwise, it goes to collateral estoppel. Collateral estoppel has a couple of applications. If you fail to act within a specific time limit, like statute of limitations, you got 4 years after a notice of acceleration to execute a foreclosure sale in Texas. If you don't execute it within that 4-year time limit, you're collaterally estopped. But mainly what collateral estoppel goes to is when you say or do a thing in the court, and that's why you have the meaning collateral. We just had Wells Fargo in a Rule 12 motion to dismiss claim that they were not the creditor, and therefore the case should be dismissed. They removed it from the state court to the Fed, claimed they weren't the creditor. I looked at that, said, holy mackerel. So I non-sued it immediately. The reason I non-sued is the lawyer made a really big boo-boo in claiming Wells Fargo was not the creditor. What he was thinking, we are not the original creditor, but he was acting as the agent for the creditor. So although Wells Fargo may have only been the servicer, they were the agent for the creditor, and they said they were not the creditor. So I non-suited right away, so they would be subject to collateral estoppel. So if they try to act as the creditor, the collateral effect of them making that statement in court bars them from making a different statement in court, even if that statement was incorrect. They made it. They did not withdraw it. They made it based on them making that statement. I took an action that dismissed the case. Now they can't come back and say, oh, yeah, by the way, we are the creditor. They're collaterally estopped. We had someone in California that Wells Fargo sued Deutsche Bank over a pool of loans. Deutsche Bank went into the court and said, we have no interest in this pool. 6 months later, they foreclosed on this woman's note, and this note was in that pool. So she went to the court and said, collateral estoppel. They can't come into one court and say they have nothing to do with this loan and then come into another court and say they do. They're collaterally estopped. Does that make sense, James? And is that the way you perceive this?
That would be correct, but where I'm going is estoppel by silence under 1635, regardless of whether it's got a statute of limitations or not. They're estoppel by silence because the statutes say they got 20 days to respond, and in that 20 days they didn't respond, they're estoppel by silence. And if they come back and they try a statute of repose or something like that, that doesn't work either because they had a duty under 1635 to act within 20 days to say one thing or another. They had an obligation and a duty.
What the statute says is if they fail to file a demurrer or an opposition to the rescission within 20 days, there's a remedy included in the statute. If they fail within 20 days, the borrower may retain the property with no further obligation.
Yeah, then you go to 1640, 15. I think it's 15 U.S.C. 1640, and they're going to try to bring in 1635 rescission and sit there and say, well, we consummated the loan. You can't consummate a loan when you've already sit there and breached the contract. I mean, you can't come in and argue.
Well, okay, but it doesn't make any difference if they consummated the loan. That's irrelevant.
Sit there and say that there is a loan been consummated, then you can go after an unconscionable contract.
Oh, if anybody has ever read the Fannie Mae Freddie Mac uniform instrument, Whoever wrote that had to be high on coke. It makes no sense whatsoever. So you always can challenge that deed of trust. Go ahead, James.
I would agree that you can always challenge a lien.
Well, you can challenge the specific wording of the deed of trust. Right there at the beginning where it names MERS, it names MERS as the beneficiary. So when the lender comes back and files a notice of default, we say, wait a minute, who are you? You're not the beneficiary. MERS is the beneficiary, and you have this filing in the record where MERS claims to transfer beneficial interest from the original lender to some other party. Now, wait a minute.
Beneficial interest.
We transferred beneficial interest to MERS at closing. So the only beneficial interest you can transfer from borrow from the lender to somebody else is what the lender holds, and they don't hold squat because you gave it to MERS. That's what the contract says. The clear wording of the contract. The least sophisticated consumer will read this, and it says MERS is the beneficiary. That means MERS is the beneficiary, not the borrower, not the lender. How else do I read that?
Okay, now, would that not be an unconscionable contract when you bring in Carpenter versus Longan and go back to a previous covenant within the deed of trust that said we will follow all federal, state laws and all final...
Covenant 16. Covenant 16, absolutely. And Covenant 21 gives a clear intent to breach Covenant 16. Covenant 16 is the applicable law and severability clause. And both parties agreed to abide by all law. That's the main claim that I bring.
Yeah, and if they don't follow all federal, state, and equitable laws, they violated the contract.
Yeah, exactly. They repudiated the contract. By their own conscious intents, they repudiated the contract. And that is, if you're going to fight anything having to do with a contract, before we go to securitization, before we go to show me the note, read the contract. The easiest thing to bring before a court is the clear wording of a contract. The hardest thing for them to dance around.
His equitable concerns doesn't follow law, then he's violated his oath to the Constitution.
And if he's violated due process, then you can sue the state or whatever entity he works for.
Mm-hmm. You can even go after him personally.
Only if you can show that the plaintiff lacked capacity to invoke the subject matter jurisdiction of the court, then you can go after the court personally. And we always file a challenge subject matter jurisdiction.
Randy, we're about to have to take break.
You're always making me stop when I'm having fun.
I just like to cut you off.
Randy, I'm going to holler at you later. I got kids to take care of.
Okay, thank you.
Have a great night. We'll be right back. 512-646-1984.
Kids sue parents for abuse, and sometimes rightly so. But in Illinois, 2 adult kids went after their mother for some pretty flimsy reasons. I'm Dr. Catherine Albrecht, and I'll be back to tell you about their so-called suffering.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
How's this for ingratitude? In Illinois, a man and his sister filed a $50,000 lawsuit against their mother, Kimberly Garrity, for emotional distress. Her alleged offenses include not taking her daughter to a car show, telling her boy when he was 7 years old to buckle his seatbelt, and get this, sending him a birthday card with no money inside. After 2 years, an appeals court dismissed the case, explaining that a ruling against the mother would have subjected all parents to excessive scrutiny and interference. Amen. My only question, why did it take a court 2 years to come to that decision? I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Live Free Speech Radio, LogosRadioNetwork.com.
You're listening to Rule of Law Radio with Randy Kelton, Vet Pack. All right, we just ended a call, and we're about to bring on Randy. Who are we going to bring on? We've got a couple of callers waiting.
Okay, we have Kenny from Texas. Kenny, thank you for holding on so long.
Hey, Randy. I am honored to be able to speak to you. First-time caller, but discovered you and Eddie's work, and just
wait a minute. We're having a little trouble with your mic. Move it just a little bit below your mouth.
How's that?
Much better.
Okay. Well, obvious things. I'm investigating some avenues of remedy for a friend of mine who hired a plumber, and the plumber failed to deliver.
Wait a minute, Kenny. I'm having a terrible time understanding you. I'm just getting parts of the words.
I am so sorry. I don't know what to do. Can you hear me now, Randy?
Yeah, go ahead. Let me see how that does.
I'll try my best. The subject matter of my inquiry to you, I covered your opinion on the plumber that they hired has a journeyman's license, and the occupational code, which governs plumbers' activities, says that a master plumber has to be,
a master has to pull a permit. A journeyman can't pull one, and a journeyman has to always act under the supervision of a master.
Yes. Now, there was a controversy because a 3-week estimated time for the work to be done turned out to be 7 months. Now, he was fired, and he has retaliated by slapping a mechanic's lien on the property.
Oh, okay.
Recorded into the Brazoria County record, and it seems to be quite questionable to me why he would put a confession of engaging or contracting with the public clearly in an affidavit, and he's confessing actually to his illegal activity. And according to 1301, the code that governs plumbers, he has some heavy sanctions that are.
Okay, hold on. You there's another direction to go. Go on the internet and pull up Texas Penal Code 32.49.
32.49. Okay, yes, sir.
Yeah. Okay, while you're looking that up, 32.49 was put in place by the legislature in order to stop the Republic of Texas from filing liens against public officials. Now, the Republic of Texas figured out how to do this, and it was correct, and it was within law. Created a big problem with these guys because technically they were legal. Now, the way they were being used was abusive, but it was technically legal. So the legislature passed this statute. And it says if a person commits an offense, if with intent to defraud or harm another, the person owns, holds, or is a beneficiary of purported lien or claim asserted against real or personal property, or an interest in real or personal property that is fraudulent, as described by Section 51901C Government Code. Not later than the 21st day after the date of receipt of actual or written notice sent by either certified or registered mail, return receipt requested to the person's last known address, or by telephonic document transfer to the recipient's current telecopier number, requesting the execution of a release of the fraudulent lien or claim, refuses to execute the release on the request of the obligor or debtor, or any person who owns any interest in the real or personal property described in the document or instrument that is the basis of the lien or claim. A person who fails to execute a release of the purported lien or claim within the period prescribed by Section A2 is presumed to have had the intent to harm or defraud. Offense under this section is a Class A misdemeanor.
Wow. Well, he had no contact.
That will officially jerk a knot in his shorts.
Okay, yeah, that's the people, my friend, they're actually living there. She has his wife has it's the grandmother's house that they've put into, the grandmother put into some sort of trust that upon her passing away, my friend's wife, they inherit the house. Something about a Ladysburg deed. But anyway, I didn't research that yet. But his illegality, does that prevent him from trying to do a mechanical deed that is perfected? I don't see that. He's deficient in notice. He didn't send any notice, that the Business and Commerce Code states on a homesteaded property, which it is homesteaded.
Okay.
When the contract is...
You go into a lot of stuff that may not really be relevant or necessary.
Okay.
The guy was a journeyman.
In the road. Huh?
He was, okay, hold on. He's a journeyman who contracted to do a job he wasn't authorized to do.
Yes, he's actually a criminal activity, yes.
Okay, so the contract that he entered into was fraudulent from the beginning, ab initio.
Absolutely. Yes.
So this is
to the court, or do I need to?
You take this. You send by certified mail an order ordering him to release the lien, and when he doesn't, you go to the police and file a criminal charge.
Okay. Yeah. This plumber seems to be a loose cannon, and I talked to the enforcement director of the Plumbers Code for Board of Examiners, and he wanted to know the guy's name, and I have to admit that should be a judgment call that my friend enters into, but there's a $5,000 administrative fee for him violating, and then $1,000 per item, and we've tallied up about $11,000 or $12,000 in violations. He's deficient on notice to the homeowner. He had no actual contract, and it was illegal to begin with. So I guess we'll follow your advice. All right, tell my friend to send this 39.42. And
32.49.
Yes, sir. And see if we can get him to, like you said, put a jerk in his shorts. And I think he's gonna file a complaint with the Board of Examiners too. That's the avenue to report him from. He's contracting with the public over and over and over.
Okay. Well, I'm sorry, Kenny. I'm having a terrible time understanding you. I'm only getting every couple of words. You want to try calling back in?
Yeah, thank you.
Are you on a cell phone?
Yes, sir.
I'll try to find a place where you get a better signal.
Let me try the house phone, and I'll maybe that will get.
Randy, we're going to have to take a break. This is Rule of Law Radio with Randy Kelton, Vet Pack. We'll be right back.
Easy.
I like to know just what I'm fishing for. I ain't asking for much, I ain't trying to be no glutton. I'm just here making my living, pushing buttons. I get my message out to anyone and shout and
We are back with Rule of Law Radio, Randy Kelton, Vet Pack. Randy, we've got a couple of callers. Which one did you want to pull on in?
Okay. Now we're going to go to Oliver in Tennessee. Hello, Oliver.
How you doing? Hello?
Oliver, we are getting a terrible signal. Are you on a cell phone?
Yeah, I'm on a cell phone.
Oh, that's better.
Can you hear me now?
Let me see how you sound. Oh, yes, much better.
All right. How you doing? I'm the one with the house situation. Tear down.
Yes. You're the one where they condemned your house and knocked it down.
Yeah.
And demolished it, and then you checked the law, and they apparently did not have authority to do what they did.
Right. They keep on saying that I was resident. When I went to go look at residents in the code are builders. They are contract builders, so that's why it's maintenance and building and codes. So when I looked at all the definitions and then reread all the codes, it's way off. I spoke to Eddie, and he told me to go file with the insurance company of the city.
No, wait a minute. File with an insurance company?
That's what he said.
Okay. Nah, you can't file with the insurance company because when an insurance company insures someone, they don't take on responsibility for that person. If that person gets sued and incurs a loss, the insurance company has a responsibility to pay back that person his loss. And by that, you have no claim against the insurance company because they didn't enter into a contract with you. They entered into a contract with the insured. So you never can make a claim against an insurance company. You have to make a claim against whoever the liable is.
I'm in the city. That's what I mean. You're correct.
Yeah. Yeah. So it's the city who would have to make their claim to the insurance company, not you.
Oh, well, I called up there and they called the human resources, and they direct me to their insurance policy adjuster, either attorney or whatever. And I talked to him, told my situation, and he told me to come in, fill out the forms, and he explained to me that they're responsible for physical damages, as far as like paying me for any violations of laws, like federal law, like they couldn't do anything, but physical violations as far as the house being tore down, my car being at the tow lot. He said, if you can prove that they never had authority to be on your property, he said, we would be able to cover that, but we can't cover all the other things that you can sue for until you sue for it.
Say, okay, this is my point. Yeah, and apparently the insurance company has their own people that takes these complaints. The real point is the insurance company is not liable to you. They're liable to the insured. So when they send you to the insurance company and the insurance company tells you, well, we can't pay for this, we can't pay for that, you don't care about that. Your claim is against the city.
Right.
And you tell the insurance company, well, you need to explain that to the city because we're going to sue the city for this amount and you'll either be liable or the city will be liable. For your part, you don't care who's liable. You get it from one or the other.
I mean, he explained it in that fashion. He explained it in the same way. He explained that if I find a violation, I can get to you what I can by our laws. Everything else that you think I haven't reimbursed you for, you're going to have to go through the court procedure to make us pay you for it.
That's good. Then he's giving you really good information. And I went over that not to be pedantic, just so that everybody else listening would understand that who actually has the liability. They may want to push you to the insurance company, but it's actually whoever commits the act that has the liability. But it sounds like the insurance company is not going to be terribly hard to deal with. Be careful.
No.
You can get trapped. If the insurance company agrees to pay off a claim, be careful that you don't get trapped into this situation to where they say that you already accepted payment and therefore waived all your other claims.
I understand.
They're dirty, rotten scoundrels. Okay, maybe they're not dirty, rotten scoundrels, but you have to conduct yourself as if they are dirty, rotten scoundrels.
Right.
So be real careful about that. They'll try to get you on procedure. If you sign anything, make sure it very clearly stipulates what the claims are and the limits of those claims. So that if they haven't addressed all of your claims, make sure the ones not addressed are excluded from this contract.
Okay.
Does that make sense?
Yeah, it makes sense. What can I do about the vehicles being towed?
Sue them. Did they have authority to tow the vehicle?
No, I've been trying to find the paperwork. They sent me, the tow company didn't have it. They told me that I had to go build and tow. I went to build and tows. I asked the director where the authority came from. He said he ain't having it. And he ain't have no authority. He ain't get no paperwork. He ain't give the company anything.
Then you should file a theft report.
I tried to file a theft report. The police, when I went to the police station, they told me that, because the police was there. The police arrested me before they towed my car.
Then you need to go to a magistrate and file against the police.
I tried to. The magistrate told me I couldn't file against them.
Then file against the magistrate.
You're making this complicated. Okay. So
this is what we call just the kind of running the routine on them. This is the tar baby. You go to the magistrate and you got this little tar baby and say, here, you want to touch it? Here, go ahead, touch it. The magistrate touched it. Failed to perform a duty he was required to perform. And in the process denied you the full and free access to her enjoyment of a right. That's going to be official misconduct. It's a Class A misdemeanor, even if the judge does it. So you take a complaint against that judge to a higher level judge. Was this a justice of the peace you took this first complaint to?
I didn't. I went to the police department. Then somebody told me to go to the sheriff's. When I went to the sheriff's, they took me to the magistrate because they were kind of confused. They didn't even know what to do because the whole situation sounded strange. The magistrate told me that. Okay,
hold on. After each encounter, did you sit down and write out a statement of facts?
No, but I had witnesses with me.
Okay, sit down with your witness and write out a statement of facts. You write one, have your witness write one, then compare them. This is the most valuable thing you can do. And then you went to the police department and they refused to act, so you charged them with official misconduct. You went to the sheriff and he refused to act. You charged him with official misconduct. You get to the JP, and the JP refused to act, or whatever judge you went to, and you charge him with official misconduct, and you go to a higher level judge and just walk your way up all the way to the Supreme.
But how you file? You're saying to file again? How? What's that process again?
Okay. I suggest you do it all by mail. You write up a complaint and you send it, a complaint against this last judge, and send it to the next higher level judge. And when they send you back a nice letter saying, well, you have to go to the district attorney or some other BS, then you make one up against that judge and send it to an even higher level judge. This will create you a lot of politics. This is how you get them. You'll wind up with these higher level judges going to the city saying, guys, you need to get this fixed. We're going to work you over. The higher level the judge, the more sensitive he is to politics. And the more he's afraid that his next political opponent will use your complaint against him to keep him from getting elected. Telling you, Oliver, just great fun.
Is there a complaint section in the TCA code that I have to read over and understand? How does it work?
Wait a minute. I couldn't understand that.
Is there a section in the law where I can go figure out how to complain for it?
Yes, just look. You'll have a criminal procedure code in Tennessee.
Right.
Read that section on. It's generally right at the beginning, the first 2 or 3 chapters, so I'll cover that. But look up filing complaints in the criminal procedure code. Okay, we're about to go to break, and we got a whole board full of callers.
Okay.
Do you have anything else for us?
No, I'll call it.
Okay, thank you, Oliver. Take it away.
All right. You're listening to Rule of Law Radio with Randy Kelton, Vet Pack. Call us at 512-646-1984. We'll be right back.
Yeah. Story for everyone to hear. About how we're not going to give in to the fear. Yeah, it's a story.
You're listening to Rule of Law Radio with Randy Kelton. This is Vet Pack, and I believe we're about to bring on Mark from Texas.
Hello, Mark.
Hi, Randy. Good evening. Can you hear me okay?
You got kind of a ringy sound.
Yeah, I'm on a cell phone. On the cell phone, I have a really good Bluetooth in the car, but I just fixed it. Anyway, hear me all right now?
Not much better. But I can understand you, though.
It's not a great phone. Sorry about that. So last week, we were talking about plenary jurisdiction and the potential for it to have been lost relative to a case I have where I had a judgment entered in my favor. There was then a subsequent order of non-suit with the plaintiff kind of trying to pretend they didn't know about that judgment. And then there was an order to set aside and then a motion to reopen. And you had said that if there were 30 days between some of these events, I wasn't 100% sure exactly where that would be, that the judge may have lost plenary jurisdiction. So yes. I looked at the timeline. And so if I might, I figured I might share that with him. I definitely want to ask you if you think there's a shot at that. So the judgment in my favor or the order for partial summary judgment, which dismisses the plaintiff's cause of action, was entered on June 30th, signed on June 27th. The order of non-suit was made, and then basically it was made the day before, I guess, and then it was signed on August 7th, so well more than 30 days. The order to set aside that order of non-suit was signed on August 29th. That's within 30 days. And then the motion to reopen was within the 90 days required by the rules of civil procedure, at least in that state, on September 23rd. And there was an order to vacate and reopen made immediately on September 24th, and that was signed. What do I have here? Do I have anything?
I think they made it within the time limits.
Yeah.
And they did vacate all the orders.
Yeah. He vacated the non-suit and then went ahead and reopened and vacated the order from June 30th. So all said, that happened. I still have something here where there's a violation of the rules of civil procedure, and that the plaintiff in this case never had a prima facie valid cause of action. It's filed past the statute of limitations on its face, and they never amended it in any way. And I still have a fraudulent assignment, which with Ivanova and some of these other things make it much more easy to address at this point. And I'm still interested in suing the judge for this violation of the rules of civil procedure if I've got capacity to do that, and then having that be having the vacation of his ruling in the plaintiff's favor.
That goes statute of limitations and him failing to hear it. Then that goes to procedural due process.
Right.
And he acted without subject matter jurisdiction. And you challenged his subject matter jurisdiction based on that, right?
I did. It looked very pretty. I got a little bit of help from you, in fact, and I put in some relevant Arkansas cases. I think they were fairly relevant. But all said, I made that challenge, and I said exactly what you and Steve had said to me. This was over a year ago. But I'd said essentially that the plaintiff lacks capacity to invoke the court's subject matter jurisdiction based on the complaint itself.
So
something to that effect.
So since you missed the appeal time, then sue the judge for the full amount of the property loss. And all the time it cost you. I'd sue him for 3 times the amount of the value of the property.
Right. That's nice. And that would be the value of the property if it appraised in perfect condition.
Yes.
Yeah.
You lost the benefit. He stole from you the benefit of the bargain. You had a right to that property, and you had a right to sell it at fair market.
Well, it was interesting.
And he stole it from you. It doesn't matter what it doesn't matter what you claim, as long as you can show some calculation as to how you got that claim.
Right.
Now, the other side's going to disagree with your calculation. But at the end of the day, there's only one number the jury's going to remember. That's the one you walked in the door with.
Right.
So you want that as high as you can get it. Everything will be compared to that number.
Sure. That's good. There, as I believe you've already said, it's most likely that they're going to make some kind of offer to just make this go away. That'll be really smart. So that if I sued the judge in federal court here in Texas, that's going to cause him a lot of trouble. Can't bar grieve the judge, but I could bar grieve the attorneys on the other side for aggravated perjury and have them all be parties here, I think. Right?
Oh, yeah. And you can file a judicial conduct complaint against a judge.
Oh, no, that I didn't even know I could do. That sounds good. So there's something to look into.
That'll go to the judge's bond rating.
Oh, nice. And would that strategically best be done before this suit would be filed? I think there was some discussion that if you're going to bar grieve attorneys, do that first and then sue them if you've got capacity to do it, right? So
the bar grievance kind of gives them notice. It gives them notice that they could have a claim against them, and they'll have to notify their insurance carrier.
Yeah.
If they don't, then they may not be insured.
Well, I want them to be insured because I want their insurance to pay me, right? But
well, you're likely to get in their pockets. If a lawyer gets sued for malpractice and his insurance doesn't cover it, if he doesn't pay the claim, they'll throw him out of the bar.
Okay, that's nice. Yeah, that's like trying to collect child support from a military service member. It's going to happen.
Yeah, it's going to happen.
You just go to the base and they get it done. You know, that's what I hear. So, man, that's great. That's very, very good news. I'm going to have to start doing a little further digging into this. And in the grand scheme of things, just to be sure I'm playing this right, I believe I understood from you last week that if I have some capacity to sue the judge for a violation of my rights to due process because he reopened a case that was filed on its face past statute of limitations where he really didn't have subject matter jurisdiction in the first place, then...
Yes, and let me clarify. You can't sue the judge for procedural due process. You can sue the state for a procedural due process violation, not the judge. The only thing you can sue the judge for, lack of subject matter jurisdiction.
Okay. He has immunity. If he screwed up, he's immune. But if he was doing something that he never should have done in the first place, and on the face of the document, it says, first date of acceleration 2007, filed in 2013, 5-year statute of limitations. Doesn't matter what I said after that. He did the wrong thing, and he should have told them, you need to fix this complaint and come back to me. But he didn't.
That's what he should have done. Exactly.
Yeah. Well, but by the time they got smart enough to realize it, any hope of being within the statute of limitations was already lost to them. So that's why they screwed it all up the way they did, which is very good. If I had just let their non-suit stand, that might have been a smart thing. I was hearing you. I've been listening, and shout out to Mark in Wisconsin. I would definitely wish him the best. But I heard you say something to the effect that you had non-suited something because that gave you the capacity to have collateral estoppel, and you got Wells Fargo in that case.
Yes.
Gets got a lot, but not enough. So
yeah,
they're
stuck now. What do they do?
Yeah. Well, in my case, this is a concern. A couple things I want to just bounce off you. One, in the hearing, I may have done something stupid. This judge was not really involved in judging much. He asked me a few questions. One thing he asked me when I put my motion or my challenge to subject matter jurisdiction, just kind of a notice to let him know I didn't ask him to do anything. I just asked him to be a judge. And he asked me if standing was an aspect of subject matter jurisdiction. And I think I'd read a case. I mean, it doesn't make sense to me that it wouldn't be, but I think I'd read a case that said it was not. So I said, as far as I know, it's not, rather than, you're the judge, you're supposed to tell me, or something like that. But anyway.
No, that goes to making a proactive statement of law out of your own mouth, and it is meaningless.
Yeah. He's supposed to know. But here's a question, just real quick. Is standing an aspect of subject matter jurisdiction?
Absolutely.
Absolutely it is. And it makes sense. You know what's really convoluted about all this is you have your affirmative defenses if you end up getting sued. You've got to plead some affirmative defenses within a time frame or forever hold your peace. But so if you don't, for example, recognize that the statute of limitations has already expired, subject matter jurisdiction would still let you approach that because you can do it anytime, even upon appeal, right? Is that safe to say?
Exactly.
So, nice. What I'm failing to see, and I'm curious about this, since this is an important term, you use it a lot. There's all kinds of Texas references. I go to the library at the University of Texas, and the law library's got a lot of things on it. In Arkansas, there's almost nothing. It's almost like they don't even know what we're talking about, I guess. And it's kind of a shame. But as far as it goes, subject matter jurisdiction is not the court's capacity to hear a certain type of matter, labeled as foreclosure, et cetera. Subject matter jurisdiction is the court's capacity to hear a specific matter that would, or based on its validity. I'm creating new jargon here. I'm sorry. Maybe I should just let you explain it.
Yeah, okay.
Sure.
We're about to have to take break. We'll be right back with that answer. This is Rule of Law Radio with Randy Kelton, Vet Pack. Please call us 512-646-1984. We've got over half an hour.
I had all this cool stuff I was going to say.
Well, you'll get to.
Oh, wait.
We'll be right back.
We'll be right back.
This is the Logos Radio Network.
Oh, come on.
We are back with Rule of Law Radio. You're listening to Randy Kelton, Vet Pack, and we have Mark on the line. Okay, you guys, duel it out.
Okay.
All right.
Agency, standing, and capacity. Let's say you are the CEO of a corporation and someone breaches a contract with your corporation. You have standing.
Right.
Or let's say you're a lawyer for a corporation. Let me go follow this further. I backed up too soon. Say you're the CEO and you have standing, but you don't have the capacity to invoke the court because a corporation must be represented by counsel. So even though you have standing, you don't have capacity. Now, if you're a lawyer and you're the lawyer for the CEO, now you have agency to represent a client with standing, and you have the capacity to petition the court. Or you could be in a position to where you had a claim, like in this case, but the claim expired. Now you're unable to invoke. You have a standing. You have no capacity to invoke the subject matter jurisdiction because you cannot bring a controversy to the court. It requires a controversy in order to invoke the capacity of the court to hear your claim. I just helped a guy file one in Michigan, and the way the case law was written, the judge didn't like the way I read it, but I wrote the thing, but it was what the case law said. The court was incompetent to hear the instant case because the plaintiff was unable to bring a bona fide controversy before the court. So if you're a lawyer, you must have agency to represent a plaintiff with standing with a valid, verifiable claim, and you must have the capacity to bring that claim before the court. Does that make sense, Mark?
Yes. I don't think I had that language in there that there was no bona fide controversy before the court, but I think it would have made sense to maybe add that. Nonetheless, it's still there. What I have is a situation here. Last aspect of the question, and on we go. But being that now, unlike then, I can actually see from other cases that the assignment is void on its face, not just voidable. The assignment that presumably gave the plaintiff capacity to bring the suit in the first place, it's absolutely void. So the question I'm contemplating is, would it make sense first to make some motion to vacate a void judgment, show them things from the FDIC website that have been submitted in other cases that show that they were out of business in 2008 and couldn't have made this assignment, things like that?
Yes, that's a good way to go at it. Quiet title action against that particular document, coupled with a les pendants in the record. The les pendants will jerk a knot in the shorts of whoever purchased the property, unless the bank got it back.
Yeah,
but it'll keep.
They bought it
okay.
and then resold it. But what I'm curious about is it strategic to make this motion first? And if the judge doesn't...
Yes, that's what I'm saying. You file a quiet title action, and at the same time, you file a les pendants in the public record.
Okay.
The person the bank sold the property to you would send him a notice of the list pendants. And he is not going to be a happy camper. But he's not going to be upset at you. He's going to be upset at the bank that sold him this turkey.
Mm-hmm.
So what you're likely to do is get him, because most likely he's purchased that property to flip. So good chance he's already done a lot of work to it. And you drop a list pendants on him. Now he's stuck. He can't get his money back out. He is not going to be happy with the bank. So you're likely to bring the buyer in as an ally to you.
Yes. Now that sounds good. So for clarity, because this is good, a quiet title action with a list pendants strategically might be the first thing to do. And I'm going to have to make that action probably with the same judge or with someone that he knows.
Well, if you sue the judge for acting without subject matter jurisdiction, that ends his participation.
Okay, so what comes first? Motion to vacate? The judge says no, then I sue the judge, and it's worse for the judge because I'll probably win in federal court, or the title action.
I would say subject matter jurisdiction suit against the judge.
Okay.
And then follow that immediately or at the same time a quiet title action against this assignment.
Oh, okay. So we're going to attack that document. And in this instance, MERS can't assign. I don't have to notice MERS. The party that supposedly made the assignment is out of business. I don't have to notice them either, I suppose. I suppose I notice nobody. I just put it in front of the court. Does that make sense?
Put it in front of the court. And if MERS stands up and raises an issue, let them prove up their standing.
Well, they have none in this state. So would you suggest that I do notice them and let them come try to fight me?
No.
Yeah.
If the court wants you to notice them or if they somehow find out, that's their business. Otherwise, you get your default judgment, and they have to overcome a default.
Well, this default judgment, I assume, is still going to be filed, or I'm still going to be seeking it with the same judge, probably. The same guy.
No, if you sue that judge, he's disqualified.
So, okay. Now, duh, I'm not that stupid. Sue the judge first. He can't hear this. I don't want him hearing this. That's the whole beauty of it.
Yeah. So he's history. Even if he wins your case, he's still history.
Okay. The quiet title action is doing nothing but practically asking the court to look at the validity of a document and tell me if I'm wrong. It does not matter if that document had some kind of substantial bearing on a case that went the wrong way against me. After that, we're just
has absolutely nothing to do with that. That makes this a pawn move.
It's mutual. They're completely mutually exclusive. Yes, I've been hearing your chess analogies lately, and you make them often enough that even there was something in your historical from last night, I think. But I'm getting it. The quiet title action is asking the court to look at the document. They're going to find in my favor if they're going to be honest. Although this could be something which means I have to be ready for an appeal. I need to have some money set aside or have it all written up and ready to go. And then the motion to vacate, avoid judgment, probably never going to be necessary if the suit against the judge goes the way we would want and the judge would make a deal. I get the judge to go ahead and take care of that, and they cover me with treble damages. And then I can sue, hopefully, the plaintiff in the case after they've been demolished by all of this. Does that make sense?
Yes, because your harm the settlement you get from the judge, that's harm. And that's the harm the judge caused you. Now, the plaintiff, he also harmed you. So you get to go for him separately.
Oh,
I said plaintiff. I meant you'll be the plaintiff, the foreclosing entity. So you get to take a shot at him, too.
Now, I have a loan servicer. They're probably the real plaintiff here, I think. But regardless of that, the loan servicer sent me loads of dunning letters that are in violation of FDCPA. So sue judge first. I believe since they sent me a tax document, then I can sue them for that as an FDCPA violation. And
okay,
we're going to have to take a break.
Sure.
I got this. This is Rule of Law Radio. You're listening to Randy Kelton, Vet Pack. Call us 512-646-1984. We'll be right back.
social network sites can be a privacy nightmare, but a new study says other websites may be leaking sensitive personal information about you too. And the problem is getting worse. I'm Dr. Catherine Albrecht, and I'll tell you more in just a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Quick, call a privacy plumber. Internet websites are leaking information like crazy. And the culprits aren't just Facebook and Twitter. Travel, health, and employment sites could be just as bad. Researchers found that 75% of websites leak information that could be used to track and profile consumers. Alarmingly, 90% of health websites leaked user search terms to third parties. Look up information on hemorrhoids or cancer, and there's no telling who might wind up with it. The study concludes that internet privacy is a big problem, and it's getting worse. Just one more reason to stick with privacy-friendly websites like StartPage.com. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Chemtrails. You are listening to the Logos Radio Network. LogosRadioNetwork.com.
I see two. You ever done I see tools of ingenuity. The use against the workers of iniquity. Tools of massive capability.
We are back with Rule of Law Radio. You're listening to Randy Kelton, Vet Pack. And Mark, I believe we're about to wrap you up. We've got a couple other callers we want to get on before we end the show.
Yeah, Mark, we do have something else because we've got two more callers and we're running out of time.
Oh, we're all good. I'm going to put some things together. I may call you another time here and there, but eventually we're going to contribute to Randy's beer fund. He just set it up so that I'm looking at good potential for things, honestly, to go my way, and I could end up with like $1.5 million by the time I'm done.
Yeah. You always expect to win in the appeals. You never expect to win in the trial court.
Right.
But
in order to do that, you better be ready for it, right?
And it's always better when you're the plaintiff. It's a whole lot more fun when you're going after them.
Yeah. I like the sound of it. I'm going to figure it all out. Man, thank you very much. You've been invaluable to me and everybody else, and I hope my calling in is helping many other people. Everybody else,
yeah,
see you all.
You do make a good caller. You make a good caller because you're a good, clear thinker, and I like that. That's why I spend so much time with you.
You should see me when I'm sober.
Oh, cool. Okay, thank you, Mark.
Thank you.
Okay, now we're going to go to Joe. I don't have a state on you, Joe. Hello, Joe. What do you have for us today? I might have put Joe to sleep. Joe,
that's not good.
If you can hear me and I can't hear you, you might try hanging up and calling back again. Okay, now we're going to go to Jacob in Texas. Hello, Jacob.
Hi, can you hear me?
Yes, I can.
Well, I had a pretty simple, hopefully quick question for you. I pushed forth a motion for a subject matter jurisdiction challenge. I have not gone to trial yet. It's just pre-trial, but they want to have a pre-trial hearing. My question to you is, I've heard you talk about how they just dismissed you outright and it ruined all your fun. And I was wondering if I didn't show up to this pre-trial hearing, would I know it's technically going against the due process because they have not answered my challenge to subject matter jurisdiction.
Oh, make sure you show up. I didn't show up to mine by mistake. I got my date wrong. I really wanted to be there. Okay, when you get there, they will try to start the hearing and you will say, objection, I am here at arm's length to the court. And what that means is I have not stipulated to the jurisdiction of this tribunal. I have a challenge to subject matter jurisdiction before the court. And then let the judge do what he does.
And then just let him talk about whatever he wants to talk about. Don't even just object wholeheartedly outright at arm's length.
Yeah. From there, then you go on and adjudicate your case. Did you get the information requests? A lot from me along with that subject matter jurisdiction challenge? Or did you get yours? I know I sent out a bunch of them. Did I send you my challenge to subject matter jurisdiction?
Yes, you did.
Okay. Did I also send you the information requests?
Like interrogatories?
No. Open records request to the city.
No, you did not.
Okay, send me another email. I'll send you those.
Okay.
That's what got mine thrown out.
Okay.
They couldn't prove it up. Now, you're in, where are you at?
Travis County, Austin.
Oh, okay. Actually, Travis County can enforce the traffic code, but I guarantee you the officer who wrote the ticket is not going to have the certification.
Okay.
Yeah, and so you put in this specific request. There's two of them there. And mine was in Decatur, Texas. It's a county seat of Wise County. And I know the chief of police personally. He was not a happy camper.
Yeah.
He called me, and I could hear him doing the chicken dance on the other side of the phone. But he wrote me a response stating that he could not provide the verifications for his officers because they do not enforce the commercial traffic code. Well, he told me that on the phone. And I said, well, then, what code do you enforce? And he's doing this, and I can hear him shifting from one foot to the other. And then I didn't show up in court, and the dirty, rotten prosecutor dismissed my case and ruined all my fun. Because Rex said to me, he said, Mr. Kelton, you know you're not going to get the ruling you want in this court. I said, oh, no, I know that. Of course not. I'll get my ruling in the federal court. And I could just see him on the other side. Oh, no, that dirty, rotten scoundrel. I've hammered Rex. I haven't really hammered Rex. I kind of hammered one of his officers once. His officer did something really stupid. And I went to Rex, and he said, well, Mr. Kelton, he's really a good officer. He's just new, and he's got a lot to learn. I said, well, then I'll make you a deal, Rex. I won't file against him. If you'll bring him in here, because I don't want to say anything about him without him there to defend himself, and you don't pay any attention to what I say. And he said, fair enough. When he brings the officer in, and I crawled right down his throat. And finally I told him, I'm just disgusted with this whole thing. I'm done with you. You can go. He looks up at the chief, and the chief motions him to leave. He leaves. And Rex said, you kind of rough on him, don't you think? I said, yeah, but it's probably good for him. And Rex said, yeah, it probably was. And then I didn't file on him. So he got a lot of respect for me. He found out that I wasn't just after these guys. But in this one, they chickened out.
They chickened out on you.
Don't expect Travis County to. Is it Travis County? So you'll be going before a JP?
Yes, correct.
Oh, wonderful, wonderful. You might get to sue the JP. We start suing JPs. You sue one JP, every JP in the state of Texas will know about it.
Oh, that's wonderful.
Yeah, they will really get unhappy. All the JPs know who I am because of the things I've done to other JPs. When you sting one of them, they all find out about it. So,
I have a question.
Go ahead.
I feel like I've heard before you mentioning changing the title of your or like the plate on your car, your vehicle, your mode of transportation, traveling, to change it so that it's private use only or not for hire. I don't know. It seems unsubstantiated. I haven't seemed to find anything in statutes yet.
That's probably from Eddie Craig's show. In Illinois, if you're driving a commercial vehicle and it's not a taxi cab, you have to have written on it, not for hire. It's always printed on the side of it. The reason you can put that on there is it gives them notice that you're not in commerce. It's not statutory, but it just goes to notice. That's why I had my DOT number on the back of my car. The DOT number gave them notice. I was filed with the Federal Department of Transportation as a private operator, not in commerce. They had notice.
Randy, we're about to have to take a break. All right. Are you ready?
She's always doing that to me right when I get to the fun part. Yeah.
All right. This is Rule of Law Radio. You're listening to Randy Kelton, Vet Pack. We'll be right back. We are back with Rule of Law Radio. You're listening to Randy Kelton, Vet Pack, and we are about to wrap it up. The night is almost over, Randy.
Yes, the time flies when you're having fun. Okay, Jacob, which JP are you going before? Hello, Jacob. Did we lose you?
I think we did. He may have gone to bed.
I may have put him to sleep. I have that effect on people. Okay,
I can just fine.
Is he here?
Are you there, Jacob?
I'm here.
Oh, okay. We thought we'd lost you. Okay. Do you know which JP you're going before?
I do. I know it's the number 4, but I don't remember his specific name or her name actually. So I know it's a female. Oh, yeah, not off the top of my head. I have to go back into my paperwork and look it up, but I'm in my car right now traveling, so.
Oh, okay.
Yeah.
Traveling, not driving.
Not driving, I'm traveling. I'm a traveler.
Okay, so have you filed any motions in the case yet? Other than the subject matter?
I filed the challenge to subject matter jurisdiction with all the paperwork that you sent me with that. I filed also a motion to dismiss alongside that, but not a motion to I just recently read it. It was like a motion to combine or to junction. So I didn't do that together, but I figured they would just kind of claim it as pro se, ignorance. But other than that, no, I have not.
Oh, okay. You probably don't need to, but make sure you want to get these information requests. This is something that they really don't know about. They haven't seen it before, and they have no idea what to do with it. And if they've been hammered, they might just dismiss it just so they don't have to have the fight.
Yeah.
There is another request I need to do a little research on and then put together. The Department of Public Safety keeps statistics. And one time I found on the DPS site statistics on how much each city collected in traffic fines. So I know there's a report that they have to produce that goes to the DPS. The DPS are supposed to keep all the records and statistics. So there are reports they have to send to them. And one of the things, I talk about addressing these from the perspective of playing chess. I want to ask them for stuff that'll cause them to scratch their head.
Okay.
If you file the challenge subject matter jurisdiction, and then you get these information requests asking for the police officer certification to enforce the traffic code. And then you ask for the report they're required to send to the DPS showing how much they've collected in traffic fines. Now, if they have a really smart attorney, he's going to say, why did he ask to see that? What has he got up his sleeve? That's exactly what we want them to do. I use my requests to kind of give them an idea of where I'm going. If I threaten to file a private attorney general suit against you, you might or might not believe me. But if I ask the right questions and cause you to think, he asked that question because he's going to file a private attorney general suit against me, then it's true. So I try to craft my requests very carefully. I have had great fun with them. I was in Hazel And I asked for all of this certification. And the clerk I gave it to took my request, and she went in the back, and she came out a little while later, and she had the request. And she said, Mr. Kelton, I read your request, but I don't understand what you're asking for. I said, just call the legislature. I'm sure they'll explain it. And she stood there and looked at me like she wanted to slap me. And then she said, well, Mr. Kelton, could you clarify just what it is you're looking for? You see, she didn't understand exactly what I was looking for, but she's not allowed by law to ask, only generally. I'm sorry, she's not allowed to ask me why I want to see it. And that's what she's trying to get to. She's trying to get me to be real specific so she'll know why I'm asking for this. So she said, can you be a little more, what did she call it, specific in your request? I said, oh, absolutely. I want to see exactly what I asked for in this request. And that time she really did want to slap me. Stood there and stared at me for a minute and then turned and stomped off. They never did answer them. So when it came time for the hearing, before the hearing starts, I talked to the prosecutor and I told the prosecutor I wanted to file some complaints against the city manager for not responding to my information requests. I want to file them with you. Oh, man, I can't take them. I said, sure, can. You're a prosecuting attorney. I'm not going to take them. Come on, you big chicken. It's going to be a lot of fun. It won't be any fun for me. He says, if we're going to go to trial today, I already got the jury. I said, nah, don't worry about that. We're not going to go to trial today. Oh, we're not? No. I got a challenge subject matter jurisdiction, several motions. You'll never get before this jury. And he said, a challenge subject matter jurisdiction? I said, you haven't read it? I'll read it, Mr. Kelton. He reads it. I guess he goes and reads it because we got into court. And the judge just going through these trials, and they called my name, and he said, is the prosecution ready? No, Your Honor, the prosecution is not ready. Case dismissed. I object. Mr. Kelton, you can't object to me dismissing the case. I said, sure I can. We were just about to get to the good part. Get out of my court. If they think you're coming after them and they don't know how you're coming after them, then if you want to get the case dismissed, there's a good chance that'll get it done. It's by asking really pointed questions that it's not clear what you're looking for.
Okay.
Well-crafted information requests are an art form, and I have great fun with it. So have you fought one of these before?
No. This will be my first go around. I figured it's cheap. It won't cost me a whole lot to fight it, and it'll good practice.
Well, don't be surprised if they're aggressive, arrogant, and totally ignore law.
I only assume that I'm going to lose, and if anything, if I win, then I'll be pleasantly surprised.
Don't be surprised if you lose because they don't care what the law is. It's all about the money. But one thing that you can do that I'd like to see more people doing is keep in mind that they're all public servants, and you are the master. When I go to court, judges are polite and respectful to me. If they're not, then ask them to get down off the bench and have themselves replaced with a professional judge who's competent to rule over this tribunal. Oh, they get real upset about that. Tough. You're the servant. I'm the master. You want to raise your voice to someone? You go raise your voice to your stepchildren, not to me. If you're unable to control your personal passions, you need to get down off that bench. H.G. Wells, in his Outline of History, on speaking to the corruption of the popes during the Dark Ages, very aptly observed, the giver of the law most owes the law allegiance. He of all beings should behave as though the law compels him. But it is the universal failing of mankind that what we are giving to administer, we promptly presume we own. They begin to think they own it, and it's our job to let them know that they don't own it, we own it. But above all, have fun with it. Have you listened to this show much?
Oh, I've been listening to the show for a few years now, but this is the first interaction I've had with the actual the law.
Okay, so you understand the routine.
Well, I have a good grasp of it, but I don't have good practice, and therefore I have squeaky wheels.
This will be good practice. First rule, never ask a public official to do anything you actually want him to do. Because when he doesn't, you got remedy that you can use against him. And if you never want him to do what you're asking him to do, you never get upset when he doesn't. And when you don't get upset when they don't do what you want them to, they get confused. And they start wondering, what is he setting us up for? And that really makes it fun. I am sorry we are out of time. This is Randy Kelton, Vet Pack, and Vet is going to take us out of here.
All right. It has been nice talking to everybody. You guys are doing really, really good out there. Keep listening and have a great weekend. Be safe. We'll see you next week.
Hey.